Thanks. Hey everyone, and welcome to MyHR Facebook Live for the month of April 2019. It's good to be back. You've had the pleasure of Sylvie's company for the last two of these. Usual sort of rules apply there. This is obviously a live stream, so for those of you who've tuned in live to watch us, thanks and hi. It's great to have you here. You can ask questions in the stream. I have someone in the room here helping me, and so they can call them out to me or show them, and we can answer as we go. I'm more than happy to do that. We're also recording it, and it will be available on our Facebook page and LinkedIn and on our YouTube channel. So if you want to go back and look over anything, or if you want to share this with anyone who might find it interesting, please do so. So if you're watching the recorded version of this and you have some questions, just reach out to us. Get in touch at info@myhr.co.nz or jump on our website. There's a chat portal there. You can ask questions or give us a call in the office. Always happy to talk. So, Today's topic, I'm focusing this today on employers with 20 or more employees. We're talking about the changes that will come into effect on Monday the 6th of May, that is Monday the 6th of May 2019 in New Zealand only. And this is the removal of the 90-day trial period for any employer with 20 or more staff. So if you have 19 or less staff and you're likely to stay that way for the foreseeable future, you're a small company, say, with 7 employees, and that's not likely to change too significantly either way, then today's session won't be hugely relevant for you because you can keep using trial periods in the same way you have done for the last 10 years. So jump on our website, there's a bunch of resources and guides there to help you with running effective 90-day trial periods. For the rest of you, if you have 20 or more staff, this is a significant law change that will affect you from next Monday and will affect anybody you hire from Monday the 6th of May. So I've grouped this up into 3 broad areas just to help with kind of cataloguing how we're going to talk about the topics, and then I'll dive into the details. So the broad topic areas are, firstly, what does 20 employees mean? How do you know if you are covered or not? I've already heard some confusion about that. So I'll give you some clarity on how you know if you will be affected or covered by this law. Number 2 is, what is a probationary period? The definition of them, the benefits and risks of using them. Some of you may be aware of probationary periods. You might have used them in the past. You may still use them today. But I will go over what they are so you understand. And then thirdly, it's how to run an effective probationary period. So some key steps in getting in and doing it in a way that is likely to get the best outcome for you and for your people. So those are the 3 topic areas. I'll dive straight into the first one. So firstly is, am I covered by this change? How do you know? Now again, I think for a bunch of you watching, it will be clear. You've got 50 staff, 60, 120, whatever it may be. You are well and truly above 20 employees, and you're not likely to go down. So that is the very easy group. Larger employers who are well above 20 and will stay there. Simply put, you are now, you will be covered by this law, and from the 6th of May, you will not be able to use the 90-day trial period anymore. For those of you who are closer to the 20 mark, you might have 18 or 19 staff today and you want to hire a couple more over the next few months. You might be sitting at 21, 22, and a few of them may be leaving, but you may sort of fluctuate in and around, and the count might be important to you. So how do you know? Well, the law states that if you have an employer with 20 or more employees on the day that the next employee is hired, cannot use a trial period. So if you today have 19 people on your payroll and you hire person number 20, that new person cannot have a 90-day trial period. Okay? So then what counts as an employee? So it's quite clear actually, even though there does appear to be some confusion about it, the law's not very confused. It's pretty much anyone who takes wages or salary from your business or piecework and for whom you pay PAYE. That's probably the easiest way to define them. So that means permanent staff, that's permanent part-time or full-time. So even if somebody only works 1 day a week, but they have a permanent part-time contract and every Friday they turn up for 6 hours to do some data entry, they are absolutely counted as one employee. Casual employees are included as well. Even if they haven't worked for you for a few weeks, if they are still on your books and still in your payroll system, they are counted in the employee count. And fixed term employees, for the duration of their fixed term, are counted. So if you had a fixed term employee a year ago who did 6 months work for you to complete a project and has since moved on, they are obviously not counted. But if you have somebody who is halfway through their fixed term agreement, they're part of your employee count. The other one that can catch people out is directors or owners of the company who draw a PAYE based salary. You pay KiwiSaver, you take salaries. You are an employee, you're therefore part of that employee count. Independent contractors are not. They're not employees, they're not part of the count. All you have to watch there is that the people who you are counting as independent contractors are genuine contractors. And that's a whole nother topic, and again, check out our website, we've got a bunch of resources about that particular thing. But if they are sham contracts, you may get into trouble. But assuming that your independent contractors are legit, then you don't have to worry about them. It's only the employees that we are counting. One example I'd like to use here, I chatted to a retailer recently, and they have a situation where every Christmas they get very busy and they increase from the base staff number of about 8 up to about 25. And those 25 cover a really busy holiday and Christmas period. Now, those casuals are still on the books as at today, even though they haven't worked since Christmas. I mean, the retailer hopes that come next Christmas, a bunch of them will come back. So they're holding them on the payroll. They haven't formally terminated employment in the hope that those people might come back. In reality, when I discussed this retailer's operation and how many of them will come back, in any given year, they have told me that maybe only 2 or 3 will return, and then they'll do new contracts or new employment agreements for new people. So by keeping those 15 casuals on your payroll, even if they're not working, they are still classed as employees of your business. That retailer therefore has more than 20 employees. So what you need to do is when you get to the end of that seasonal spike and your 15 casuals have legitimately finished their time with you, formally terminate their employment in accordance with the casual employment agreement. You then remove those 15 people, you go back to being a retailer of 8 staff, and you trade throughout the year like that. When you spike up again at Christmas and you hire the new batch of 15 or whatever people it is, as you move up, person number 20 in that casual pool will not be covered by a trial period. That's how that works. So make sure you keep tidy records if you are on the edge there. Make sure you remove casuals who no longer work for you, fixed term employees who have finished their term. You want to make sure that you are managing to that threshold and that your 20 employee count is genuine employees who are working for you. So that's just a tip around that, but essentially that is it. If they are an employee, as in you're deducting PAYE or paying KiwiSaver, they will count no matter what their arrangement is. Okay? Secondly, what is a probationary period? So a probationary period is distinctly different from a 90-day trial period in that a 90-day trial period was defined by the law. It had a whole bunch of rules and regulations around it that were specified in the Employment Relations Act. The probationary period is something that is defined by an employee with an employer, with an employee in the employment agreement. It does allow you to let somebody go within a specified time frame, subject to whatever criteria you establish, as long as that criteria is fair and reasonable and your process is fair and reasonable. So that could be performance, conduct, behaviour, capability, those sorts of things. Obviously cannot be discriminatory for discriminatory reasons at all, and so you need to make sure that you're really clear on why you're doing it. One of the ways, and this sounds a little maybe negative or confrontational perhaps, but one of the best ways, honestly, to think about what a probationary period is effectively it's as if you are hiring somebody on a final written warning, right? So you may then give, you may pause and think about whether you want to run probationary periods if that sends the right message to your staff or your new staff, but essentially that's what it is. So the probationary period says that within this time frame, 3 months or 6 months or 2 months, we will assess your suitability for the role, your performance in the role, and we may, subject to feedback and process, terminate your employment during or at the end of the probationary period if we're not satisfied along those lines, right? So it gives you the scope to do that without having to go through a verbal warning if you do them. As you know, we're not fans of verbal warnings here at MyHR, or say a record of discussion process, a formal written warning step. You're straight really at what the final written warning has achieved, and that is we have an issue with you, we outline that issue, you have a right of reply, and then we may let you go at the end of that. So the 3 stages of a normal warning process are not required. That's what the probationary period effectively allows you to shortcut. Okay, so what are the benefits of a probationary period versus the old 90-day trial period? Well, one, it can be as long or as short as you want it to be by agreement with the employee. So it might be 3 months. That is certainly the most common, and that was the basis, I guess, for the 90-day trial period law. But you could make it 2 months. You could make it 3 months with a right to extend it by another 3 months if you weren't satisfied. I have seen 6-month-long probationary periods in particularly complex roles. Keep in mind, though, of course, the longer it gets, the riskier their job security may feel for the employee. But then at any time, if you're really satisfied that they are doing great, you can turn off the probationary period if you want to send a positive message to your people as well. So yeah, you can extend it. You can put it on pause when people go on leave, which you could not do with the 90-day trial period. So if you hire someone who has some pre-arranged leave to go see their brother for a wedding in England or something like that, they can head off for this pre-arranged leave. They've come and worked for you for 6 weeks. They disappear for 3 weeks unpaid leave. They come back and recommence their employment. Under the old 90-day trial period, that leave counted as part of their 90 days. Under the probationary period, it does not. You can pause it and you can restart it. And essentially that's the basis of it. It is defined between you and your employees in the employment agreement. You write it. So you have a lot more control over what it covers and then the process that you follow around it, provided your process and your reasons are fair and reasonable. So those are the benefits. The risks, well, there's no protection from a personal grievance. So the 90-day trial period that you are no longer going to be able to use had a very specific protection against grievances for unfair dismissal. That does not exist with the probationary period. So you may let somebody go at the end of or during the probationary period, but they may raise a personal grievance for unfair dismissal, for unjustified disadvantage, for discrimination, for a combination of all of those things potentially. So there is no protection. You are in the same process as any other employment process or arrangement. So you may ask, well, why bother? What is the point? Well, the point is you are still able, don't forget, to go straight to that termination outcome without going through the formal written warning and the final written warning steps. Okay, so it gets you straight to an outcome. And provided your process is clear and your employment agreement is clear, even though you're not protected against a personal grievance, you're in a very strong position to defend it. And I'll talk more about that in the next section. One of the other, I guess, risks or drawbacks of this process is that more consultation is required. And I hear a lot about this. I don't think it's such a great problem. It just means that you have to engage with your employee and consult with them around the termination like you would in any other way. Sit down, present your concerns in writing, adjourn, give them the opportunity to think about it, seek representation, come back and give you a response. The nice thing about this process is that you're engaging the employee in potential improvement opportunities. So someone who you hired who didn't quite work out the way you thought, they may be able to come to the table and give a reasonable explanation as to why they haven't had a very good start, and you might be able to fix that. And then, they could improve. I've definitely seen that happen. Clearly, if they're major issues, then the likelihood of improvement may not be there, but you do have to follow that step. So it's bureaucratically a little more onerous. There's a bit more paperwork and process around it. Okay, risks and benefits. So the last one, closing out and really sort of hopefully setting you up for this from next Monday, is how do you therefore run an effective probationary period? So the first thing, absolute must, is it must be in the employment agreement. A probationary period does not apply automatically. It does not just automatically apply to every new employee that they are somehow, without knowing it, covered by a probationary period. So you must write it in the employment agreement, and I strongly recommend you have a very solid clause around this that is quite clear on what you will do and how you will do it and how you will conduct yourself and what the outcome of failing to meet the requirements of the probationary period may be. And the reason for that is that the employee is agreeing to this when they sign up, when they start their job with you. They sign that employment agreement and they're agreeing to the probationary period. It can be useful to remind them of this when you are in a dispute or you're in a process where you are managing them within the trial period. They agreed to it. It was part of those initial terms of employment. They're of course entitled to try and negotiate out of it or to negotiate changes to it. But ultimately, if it is in there and it is a robust clause and they sign their employment agreement, they have agreed to be governed by that probationary period. So that's the start point. You've got to have it there, otherwise you don't have a probationary period, full stop. The second thing is have a well-structured induction plan and follow it, okay? And again, this is where systems are the key, and clearly, I'm selling a system, so I'm a little bit biased here, but honestly don't care what you use other than the fact I think MyHR is the best one out there. But have a system, put this online, use something that is automated, that is electronic, so you get the reminders, so you meet with people regularly, so it's all captured. You're not running around with bits of paper. Your induction plan shouldn't be on a bunch of sort of paper checklists anymore. It should be part of a system that will help you manage it. Follow up regularly, meet with the employee, give them feedback. And these meetings, they only need to be sort of 5 or 10 minutes. Hey mate, we're at the end of your first week, it's gone really well, here are the things I think you've done really well. Got a couple of concerns. Those concerns are this: on Thursday you were 15 minutes late to work, we didn't know where you were, that's going to be a bit of a problem for us if we can't sort this out. And the second thing is your learning of this particular process is going a bit slower than we expected. Is there anything we can help you with around this stuff? You make your notes, you move on, and that could be all it is. It's that weekly sort of check-in. But if those two problems in week 1 become bigger problems in week 2 or by week 3, you've got something to build on. You can take action. Don't wait to the end of your probationary period, the day before the end of the 3 months and go, okay, this is completely hopeless and it's not working out and I've given no feedback the entire time, but I'm going to try and sack this person effectively. There is a very high chance you would not succeed in defending a grievance against you if you waited till the very end and did nothing. So a good, well-structured induction plan. Meet regularly, give feedback, provide support and training, and then follow up. Just don't let things lie. And then if it doesn't work out, the other way to make sure you run an effective probationary period is when you have that meeting around the potential termination of employment. It is much more like, or in fact it's exactly like, your traditional disciplinary process. As I said earlier in this session, that involves you articulating your concerns in writing, presenting those concerns to the employee, giving them an adjournment opportunity to go away, seek advice, ask questions and formulate a response, then to return to a meeting and provide you with a formal response around whether they agree or not with your concerns or what they may or may not do about it. You then need to adjourn and consider what they have said, perhaps investigate further if that's required, and then you make a determination. And if you're going to consider terminating employment, then it's the same process. You propose termination. They have a right of reply in relation to that, and then if you still determine that that is the outcome, then you proceed with the termination. So it is those formal and structured steps. Okay, but you only really have to do it that one time unless you are agreeing to go back and restart the probationary or you need to do further investigation. So there's a little bit more to it, but it will still arrive at the same outcome you had with a 90-day trial period. The other thing about that is this mostly relates to things around performance, okay? I'm talking about the processes that involve you giving feedback because somebody's not performing in the role, they're not up to standard. This does not really affect serious misconduct. Okay, serious misconduct is still its own thing. Serious misconduct are those heavy things that happen in employment that justify what we call summary dismissal. Some people refer to it as instant dismissal. We don't really like that. Again, there's no such thing as instant dismissal. But those are the sort of, fighting, stealing, fraud, drug taking, serious health and safety breaches, those sorts of things that commonly fit in that category of serious misconduct. That still exists, and that can happen within a probationary period or out of a probationary period, and termination can be without notice once you've concluded your investigation and process relating to serious misconduct. So probationary periods are really more about that whole performance piece and how you are going. Serious misconduct during the probationary period, you can use your probationary period clause, or you can simply use the fact that it is serious misconduct. So notice doesn't apply, so there's no difference between the notice period and the probationary period or the notice period outside of it. So serious misconduct kind of stands alone here, okay? So that's it. That's the sort of most succinct way I can bring this all together without putting you all to sleep. So I hope that has been helpful. I'm going to look over at Isaac and see if we've got any questions through. We're all good, which is excellent. So I hope this was useful. Questions after the fact, please fire them through. And we look forward to catching up next week with our next topic. Don't forget to like us on Facebook and follow us on LinkedIn and all of those things. Thank you very much. See you later.